The Indian arbitration regime seems to be undergoing a paradigm shift primarily due to two key developments. First is the decision of the Supreme Court in Delhi Metro Rail Corporation versus Delhi Airport Metro Express Private Limited, which was pronounced on April 10th. And second is a June 3rd office memorandum released by the Ministry of Finance. So let us first talk about the Supreme Court's judgment, which has to some extent baffled arbitration practitioners in India and arguably taken India two steps back in its aim to become a global arbitration hub. The Delhi Metro Rail Corporation, or DMRC, a public sector company, was looking to set up an express metro line to Delhi's international airport through a public-private partnership. For this, Delhi Airport Metro Express Private Limited, or DAMEPL, was engaged as the concessionaire. The concession agreement was signed in 2008 and commercial operations began in 2011. In 2012, some disputes arose between the parties regarding defects in the viaduct and its bearings. Now, viaduct is the high bridge supported on pillars on which you often see metros run. DMAPL claimed that the viaduct and its bearings were damaged at multiple places, which impacted the safety of the metro and needed to be fixed by DMRC. Whereas DMRC claimed that all viaduct bearings were in order and only some grouting was loosened. Eventually, in October 2012, DMAPL terminated the agreement and DMRC initiated arbitration. A 3-member tribunal was constituted in August 2013. It gave a unanimous award in May 2017 and directed DMRC to pay approximately $3.45 billion plus interest. Now, DMAPL was also directed to pay approximately $5.5 million as outstanding concession fee. Aggrieved by this award, DMRC challenged it before the Delhi High Court under India's Arbitration and Conciliation Act. The single judge dismissed the challenge. DMRC then filed an appeal before a 2-judge bench. The division bench partly allowed the award and set aside everything else. Now, of course, this time DMAPL moved the Supreme Court. A 2-judge bench of the Supreme Court allowed the appeal and restored the original award. DMRC then filed a review, which was also dismissed. Now, despite the dismissal of the review, DMRC filed a curative petition. Now, while hearing this curative petition, the Supreme Court clarified that it should not ordinarily entertain an application seeking reconsideration of an order which has otherwise become final on dismissal of a review, but the present case was an exception as the arbitral award would result in grave miscarriage of justice. The Supreme Court set aside the award on the ground of patent illegality. As per the court, the tribunal did not interpret the concession agreement correctly since incremental progress to cure a defect, even if it did not lead to complete curing of defects, was an acceptable course of action to prevent termination by DMAPL, contrary to, of course, what the award held. Now, by completely substituting the tribunal's interpretation of the agreement with that of its own, the Supreme Court has certainly deviated from well-established principles. Now, this could set a bad precedent as most aggrieved parties are likely to focus on patent illegality while challenging an award, thereby possibly asking courts to reappreciate evidence. If this ends up happening, then it is probably for sound but rather unfortunate reasons that the Ministry of Finance released its office memorandum of June 3rd, which was my second point. Now, as per this June 3rd memorandum, the government has essentially advised its entities against routinely using arbitration as a form of dispute resolution in procurement contracts and tenders, and especially in large contracts. It states that arbitration has not achieved its overall purpose of being a swift remedy as most awards are challenged and there are multiple instances of wrong decisions on facts and improper applications of law. Now, accordingly, the ministry has recommended opting for old school litigation as opposed to arbitration. This is a big blow for India's arbitration regime because if the government, which is one of the biggest contracting entities and litigators in the country, does not have faith in arbitration, very few private players eventually will. So I do hope that in the days to come, this June 3rd memorandum is withdrawn by the government.